afternoon, good evening, wherever you are. I'm Yuri Nemens. This is the third of a webinar series dedicated to the problem of Interpol abuse and defending the rights of individuals on the international wanted list. My co-panelists today are Michelle Aslund of Aslund Law in Miami and Ben Keith, a barrister at 5 St. Andrews Hill in London. During our first two webinars, we talked about Article 3 of the Interpol Constitution that strictly forbids the organization from engaging in any activity of a political, military, religious, or racial nature. During our second webinar, we talked about Article 3, which says that Interpol must act in the spirit of the Universal Declaration of Human Rights. And we also talked about the Commission for the Control of Interpol's Files, an independent body within the organization with exclusive jurisdiction to adjudicate requests from individuals. A disclaimer, nothing that we discussed during our webinars is intended to be legal advice or to be applied in any particular case. So today we would like to talk about why abuse happens and how it happens, about different loopholes in Interpol's rules that allow governments to engage in Interpol abuse to persecute rather than prosecute. Article 2 of the Interpol Constitution says that Interpol exists to ensure and promote the widest possible mutual assistance between all criminal police authorities. Interpol member countries communicate using what Interpol calls requests, and there are different types of requests: notices, diffusions, and messages. Notices are published at the request of a member country, submitted through its National Central Bureau to the General Secretariat of Interpol. A red notice is probably the most well-known that we usually talk about. Diffusions are sent directly, bypassing the General Secretariat, but still via Interpol's channels. They are recorded in the Interpol database, but there are no meaningful requirements in Interpol's rules that would force governments to choose a red notice over a diffusion. The only real difference, so to speak, in Interpol's rules concerning diffusions is that they're supposed to be communicated to some, but not all, member countries. However, diffusions may be published for the same purposes as notices, including red notices. In other words, to detain for the purposes of extradition or other similar lawful action. Diffusions are also much more popular among member countries than red notices, obviously, because again, they don't have to go through any pre-screening by the General Secretariat. And governments use them more and more often and abuse them as well. And there are also messages that are also sent directly between or among governments. They are not recorded in Interpol's databases unless the government source requests otherwise. And finally, there is a stolen and lost travel documents database that became an issue fairly recently, as opposed to notice and diffusions. We will talk about it as well. The problem with red notice abuse is that when government requests are submitted to the General Secretariat for their publication, the oversight is still very insufficient. Red notices must meet what Interpol refers to as minimum criteria and minimum data requirements. For example, red notices must not be published for political persecution in violation of Article 3. They must comply with Article 2. They must not be published for the purposes of private disputes or family matters. Minimum data requirements, this includes usually personal data and so forth. From the minimum information that Interpol requires governments to submit for their red notices to be published, it is really easy for Interpol to figure out, for example, if personal data requirements have been complied with. But it's usually impossible to appreciate all the circumstances surrounding the case and therefore evaluate if a request for the publication of a red notice complies, for example, with Article 3. That is, if the criminal case behind the red notice is not predominantly political. And Interpol recognizes that these minimum requirements are not enough at the entrance, and as a result, a more comprehensive review is conducted by the Commission for the Control of Interpol's Files. However, it's done after the fact, that is, after a red notice is already published or the government request, and often, unfortunately, after an individual is already detained. The Commission for the Control of Interpol's Files considers requests from individuals. It does not, usually does not do any checks at its own initiative. Governments learn to trick Interpol. They charge their opponents with ordinary law crimes as opposed to political offenses, for example. In other words, they usually charge their political opponents with crimes like fraud or misappropriation, or even terrorism. Some countries do that as well. Whereas behind that criminal case is usually some political activity that the government simply doesn't like. Another problem that causes that contributes to Interpol abuse is that even if we practitioners manage to help our clients and have them removed from the database, obtain a decision in their favor from the Commission for the Control of Interpol's Files, the Commission itself has admitted that there have been cases in which the same governments were able to put the same individuals back into the Interpol database. This is how it happens, and again, this is confirmed by the Commission in one of its recent annual reports. After red notice was deleted, the same government was able to issue a diffusion because, again, it doesn't go through the pre-screening from the General Secretariat. The same individual ended up in the database, and then after diffusion was deleted, the same governments were able to use the stolen and lost travel documents database with regard to the same individuals, which suggests that, at least at the time when that report was published, Interpol did not possess any meaningful mechanism of to enforce its own decisions. Then there is also lingering old data. The rumor is that Interpol has certain software that allows governments to have their national systems updated, national databases updated after Interpol deletes a government request. However, it is unclear how many and which governments subscribe to that, and taking into consideration that there have been cases, including recently, of the same individuals whose red notices were deleted, detained in other countries just based on the old data that is still recorded in those national databases. Another problem with Interpol abuse is wrongful perception from member countries. That includes democratic countries, including here in the United States. For whatever reason, governments often think that Interpol is something more than it actually is, whereas really, usually just we refer to it as usually as just a database. Interpol does not, again, by its own admission, it does not want anybody. It's not looking for anybody. It's not its goal to extradite or prosecute anybody. And Interpol has stressed that a red notice is not an international arrest warrant. Nevertheless, you can see those descriptions, and even in some judgments of immigration courts here in the United States. And both the United States and European Union acknowledge that red notices alone are not sufficient to arrest somebody or even to begin extradition. Nevertheless, this practice still exists because of this wrong perception. Michelle, if you can talk about red notice maybe a little bit more.
Thank you, Yuri. Can you hear me okay?
Yes.
Okay. I want to say thank you for having me. I think this is a great idea. It's something that's important to talk about, and I'm particularly happy to be here with you and Ben, who are two extraordinary attorneys. So yeah, I thought that today I would talk about the way that a business dispute might lead to a red notice. And there are times when Interpol certainly should know about that. It should be recognized immediately upon receiving the request that something is really truly not a criminal matter. And there are times when Interpol has no way of knowing that because of the way the information is conveyed. by the member country. So I thought I'd give two examples and kind of give illustrations of the way that normal, regular business person who is going about their business legitimately can fall into the really terrible and protracted process of being a red notice subject. Um, the first example is a case, and by the way, both of these cases are examples where, obviously I'm not going to name the clients, but I have received their permission to talk about the cases because they both feel very strongly, the clients in both cases feel very strongly that they wouldn't like to see someone else suffer in this way, so they've become kind of activists in their own way. The first case arose out of Mozambique. And there was a father and a son who had a manufacturing company there in Mozambique, but they also had activities related to their business occurring in India and the UAE. They had a business partner, and there was a dispute with the business partner. They sued the business partner and won a judgment against him for several $1 million in the UAE. And the clients attempted to enforce the judgment. The former partner, by now former partner, was not connected to anybody in the UAE or in India, but he had very strong local connections to in Mozambique to law enforcement. And he was able to get charges filed, which were completely fabricated against the clients for falsifying customs documentation in Mozambique. And once he was able to get those criminal charges filed, he was able to get a red notice issued against both the client, the father, and the son. And the son was really very removed from any dealings he had had with his partner. So it was quite interesting that the son's name was successfully the subject of a red notice. Obviously, the former partner's goal was to try to discourage my clients, from taking any kind of action to enforce the judgment that they had gotten against him in the UAE. It was also to try to get leverage over their civil dispute, which he viewed as ongoing, even though there had been a judgment issued against him. So obviously, Interpol issued the red notices, and while we were working on the case, this is the best ever, the clients started to receive offers to remove the red notice from the local authorities via Facebook messages, via WhatsApp messages, in writing, just clear as day. So it went to show how normal and how accepted culturally, and this happens all over the world, how normal it is for local authorities to expect to be compensated for completing a task, which they should or shouldn't do, but they were very comfortable supplying that information in writing. So obviously we conveyed that to the CCF along with the other information we compiled in the form of a red notice removal request. So in this case, the invalid red notice was possible because of corrupt local law enforcement. Interpol received a request that looked like a legitimate removal request for a criminal act that also could have been administrative, but they did have a criminal article of their criminal code cited. They had cited the correct language that they needed to, asserting that there was a criminal act that had occurred and all the criminal elements were properly laid out. And Interpol just would have had no way of knowing what happened in the underlying situation. This was essentially an arrest warrant that was purchased by local corrupt police officers. We were able to remove the red notices, and we had more than enough proof to establish that the underlying dispute was not criminal. It was a private civil business dispute. It was corruptly obtained. But to get there, the client's business suffered. They had an incredible personal toll taken on them in terms of just stress. They were having to fight in a variety of venues against their former partner, and now a fight with regarding Interpol was added to that fight. And they also had to deal with reputational damage. So it was good that Interpol made the right decision eventually. And they did it in a timely fashion. I don't mean to indicate that it took too long. It was, when I say eventually, just this was a very long journey for the clients. And and it was possible because of local corrupt law enforcement officials. And when you have an organization like Interpol that has such a variety of levels of corrupt or non-corrupt countries, this is, I think, a natural consequence of it. And one thing that Interpol could do to prevent falling prey to this type of thing is giving a bit more scrutiny to countries where there's a record of corruption and red notice abuse. So that's the first example. The second example is one that Interpol absolutely should have recognized upon receiving the request for the red notice. This was a client who also had a multi-country situation. He was from Brazil. The red notice arose out of Paraguay, and he found out about it when he was on vacation in Italy. This client had a business that took over some operations of a former state-owned manufacturing company in Paraguay. The facilities had become run down and they were almost inoperable while they were under state control. So the client made efforts to modernize, to become more efficient, and get things working properly. That was met with very strong resistance by the labor union, which happened to back the ruling administration at the time. And eventually the client realized his efforts weren't going to be successful. So he moved the company into a form of restructuring that was comparable to bankruptcy. One of the creditors, who was listed by the bankruptcy court as a creditor, and he was actually scheduled to receive an apportioned payment of the debt owed, did not want to wait for the payment. So instead, he was able to file a criminal complaint for fraud, which was well received locally. We believe it was based on a bribe. We haven't been able to prove it was based on a bribe. And the criminal elements were never listed in the complaint, but they still got an arrest warrant. The court issued it. And they also obtained a red notice, despite the fact that the criminal elements were not listed in the request for the red notice. So this should never have happened. The client learned when he was on vacation in Italy that he had a red notice. He was detained, and he hired my firm during his extradition proceedings, which lasted for over 9 months. Because of the creditor's complaint that was allowed to lead to the red notice, this client had to pay attorneys in Italy to fight extradition. He had to live in Italy for the entirety of the extradition proceedings. He wasn't allowed to leave. So obviously he had to pay for that. He had to be away from his family. And he also had to seek the removal of the red notice. Eventually he prevailed on everything, but he never should have been the subject of the arrest warrant or a red notice. This invalid red notice was possible because a local domestic court allowed a civil matter to be filed as a criminal matter improperly, and because Interpol didn't sufficiently scrutinize the red notice request when it was received. It should have recognized that a proper allegation of fraud, which was the charge alleged, was not set out, it wasn't laid out properly. And on this one, Interpol should have demanded more information prior to publishing the notice, or should have just denied the request for the red notice. It's not unusual to see businesses get caught up in this kind of a situation. It is preventable in the sense that there's more scrutiny needed, obviously, when the requests come in. And when the requests come in and they appear to be legitimate, but they're coming from a country with a tough record or not a great record on human rights or on corruption, those need to have a higher level of scrutiny. So those are my 2 examples. And if you guys have any questions, that's great. But that's what I was going to present for today.
Ben, do you want to add something, and I'll gladly follow up.
No, I'm happy to press on to my section, and Michelle's covered that very comprehensively.
I just wanted to, Michelle, thank you very much. I just wanted to comment on a couple of things that you mentioned. So rightly mentioned. So first of all, you mentioned an arrest warrant in the first case, and on Interpol's rules, that contributes to abuse, because at the entrance, when the government submits requests for red notice, they must refer to an arrest warrant, but Interpol has virtually no ability to establish if an arrest warrant behind the red notice is actually lawful, valid. So there have been cases in which red notices and diffusions were published based on an arrest warrant that had been invalidated. I've seen cases like this. That's again another problem. And then when it comes to businessmen becoming targets of unlawful government requests submitted via Interpol's channels, Interpol has this provision that a red notice or what they now refer to as a red diffusion or a wanted diffusion should not be published when there is a private dispute behind them. There is a problem with that as well, because that private disputes provision in the rules on data processing isn't defined. So there is, despite the fact that the Commission for the Control of Interpol's Files has published over 40 excerpts from cases, real cases that it has adjudicated so far, none of these excerpts defines what a private dispute is. So
yeah, and that becomes problematic, because sometimes you have something that is it's a business dispute, but it's between a government agency and a private actor. So it's not private, but it's business.
Yeah, it might be that as well. And interestingly enough, the Commission has actually opined on the application of Article 3 to the private so-called commercial disputes between, well, non-political per se disputes between a private party and a government. They've been a case in which there was an arbitration between the government and the individual, and all of a sudden the individual becomes a target of a red notice or a diffusion, a criminal prosecution in that same country. But the private disputes provision, I agree, it may apply to that, but I think it can only apply to situations of so-called, well, in the former Soviet Union, it's become known as corporate raiding, which is a perfectly legal term in many other countries, but there it received its own sort of definition, its own recognition when there are two private parties and there is a commercial, for example, commercial private disputes between them, and one of the parties uses a corrupt government official to launch a criminal case against the opposing party in a civil dispute, so that it's easier, so to speak, to negotiate with that other party. And then, as a result, of course, the commission adjudicates these cases, but it's never clear if the private dispute provision should be applied. I think it should be. I think it's pretty clear. And the third point I wanted to bring up is when you say it's preventable, I agree, because Interpol must act preemptively. It's in the rules. I mean, they have to do that. They have to prevent abuse as much as possible, which they clearly don't do in most cases. And when we file a complaint, we usually file a request for access first to know if the individual is in the database, and if yes, what that information is, and then we prepare a complaint. But there are also so-called preemptive requests that individuals file. Interestingly enough, a preemptive request is not something that's defined in Interpol's rules, unlike a complaint or request. But Interpol recognizes that these requests are filed in the Commission for the Control of Interpol's Files annual reports. Because preemptive requests, nevertheless, are not recognized in Interpol's rules, there is no procedure for their consideration. So you file a preemptive request warning Interpol that there might be an abusive request coming from a government in the future, but you do not receive any response from them, except, of course, in acknowledgement that they received it. But there is no a response in terms of if they're going to act on it or not, if such request, as a matter of fact, arrives. So yeah, these are the 3 points I wanted to mention. But let's go to the stolen lost travel documents database.
Well, but just before I do that, I just want to pick up on the private dispute point. So I've done a lot of corporate raiding cases involving Russia, Ukraine, Kazakhstan, and former CIS states, and I suppose the private disputes issue, I never really think it arises in those cases, because you've almost always got political interference. And so by very definition, corporate raiding, it's misusing power, it's misusing political influence, whether it's clan or the local mayor or whoever the local prosecutor is, either by bribery or friendship or relationships or whatever it happens to be, in order to get a red notice issued. And the same way, as both mentioned, the red notices occur in often alongside civil disputes, sometimes deliberately as leverage. So I've seen it in arbitration proceedings. I've seen it in there was very high-profile divorce proceedings in the UK, where there was mention of a red notice being issued against the wife who was suing a very wealthy Russian, and they were all designed to leverage the civil proceedings. I suppose I never get down the ladder for the private disputes in those cases, because I think the concept of corporate raiding is quite easy to show is political in an imputed political opinion way. And I suppose that's the thing when we're probably for another seminar, but the difference between overtly political and imputed political opinion is something that's sort of known as the Refugee Convention, where you're trying to show that somebody's collision with state interests or individual members of the state, prosecutors, police officers, etc., make them at risk of political prosecution. I think I've always thought more of the private disputes when I have to use that, as particularly Indian cases involving dowry offences or family disputes, often that sort of thing. Some of the child abduction provisions, those sorts of things, which are sometimes criminal in some countries and often not in others. I mean, I don't think there's a hard and fast rule, but that's of those topics.
I see Ben's point, and I think that I wonder if this has been your experience as well for the two of you. There have been times when I've seen a case as being much more political, but then the decision we get back addressed that issue, but the CCF decided to land its decision or base its decision on something else, like one of the other grounds that we've argued. And so from my perspective, certainly we assert every argument that we have. I do feel like in Russia and some of the other countries where we see corporate raiding, there is an inextricably intertwined elements of the private dispute with economic and political status. You can't make that argument absent one argument without the other, because of the nature of the country and how economics and politics work there. But I have definitely seen decisions back where we thought one argument would be the prevailing argument, and the CCF decided to really focus on another one, perhaps because they didn't want to make a politically motivated decision. I'm curious about your experiences with that.
I mean, similar, Michelle, in that often what seems to me to be a pretty clear political offence, you might run a different argument as well, as a sort of subsidiary, and you might win on that unexpectedly. And it's not that they decide that it's not politically motivated; they just don't make a decision on that. They just,
right,
like a judge might, particularly in the UK, the judges might just say, well, I can remove the red notice on the basis of something else, and I don't have to make a political decision about this particular country.
That's right.
Or sometimes, I mean, I've just had you spend all this effort to get a red notice removed, and you just get a 3-line letter saying, "Thank you for your correspondence. There is now no longer a red notice on the system for you," which is a win, but you don't know which bits worked and which bits don't work sometimes.
Right.
I think that to what Ben just said, I agree that private disputes or private matters can be interpreted in the sense that it's about some local custom or family matter, especially that same provision is private disputes are mentioned alongside family matters. But at the same time, I think there is a because again the term isn't defined. I'm still wondering if we could apply private disputes provision. There is literally no definition to that expression in Interpol rules to cases like corporate raiding. I personally believe it's possible, because I mean, again, depending on if CCF ever gives a definition to the term, any definition. In terms of the application of Article 3 to these disputes. Again, it's absolutely true, and the CCF is already applying on that. I think that you can apply both. I agree with that concept as well, both Article 3 and the private disputes provision to the case of corporate raiding, because Ben is absolutely right. When a government, and as a matter of fact, even though I'm not an immigration lawyer, but I've seen immigration court decisions in which immigration courts have said that even if there is no political conduct on part of that individual, the fact that the government gets involved in certain private dispute because of corruption and so forth, that in itself might constitute a predominantly political offense. So, in other words, when a corrupt government official interferes in a private dispute to help one of the parties, I think Article 3 applies. And even though CCF's decisions on the application of Article 3 to commercial disputes, private disputes, is by no means, in my opinion, clear. I think there is definitely some hint that they're willing to apply Article 3 to those cases as well. We can move, if you want, we can move to SLTD ban, or we can discuss this.
Tim, let me give a quick overview of SLTD, which stands for Stolen and Lost Travel Documents. And Stolen and Lost Travel Documents is a separate database of Interpol, which they keep of stolen and lost travel documents. So a country will report that a particular individual's travel documents are lost or stolen. And what that means is that when you try and cross a border using a lost or stolen travel document, that you are stopped at the border, that document is obviously taken from you, and then you are deported to your country of origin. So this is designed to be a useful mechanism to stop people breaching immigration controls and stop people stealing passports and making false passports and that sort of thing. However, it is hugely open to abuse, because it's even more open to abuse than the diffusions of red notice that we've talked about so far, because the countries in question don't have to give any reason. They just have to make a report and say these documents are lost or stolen. So if this individual crosses a border, please stop them. Oh, well, not an individual. If somebody uses this passport across a border or travel document, please stop them, return the passport to the local Turkish embassy, and return this person, sorry, I talked about Turkey, but that would come to them, and then return them to the country of origin. And by far the worst abuser of this system is Turkey. And it is used essentially to circumvent extradition proceedings, because you don't need red notice provisions, you don't need to accuse anybody of anything, you just need to say their passport is stolen or lost. And so I've received calls from clients who've crossed a border in Europe to say, I've just landed in this country and I've been stopped at the border and apparently my passport's been reported as lost or stolen. And they are absolutely terrified because their country of origin, where they don't live, have prosecutions out against them. And particularly in Turkey, that usually relates to members of the Gulenist or FETÖ movement. I mean, just to give you by way of example, a brief run through Turkish politics. In 2016, the attempted coup, allegedly by Fethullah Gulen, led to a huge purge of civil society in Turkey, including tens of thousands of civil society actors, teachers, academics, lawyers, judges, being either fired from their judges, and thousands of people being placed into prison, simply for being friends to the wrong people, publishing things online that criticised President Erdogan, or being related to the wrong people. In 2016, Turkey registered 100,000 passports as stolen or lost. And the problem is that when a country does that, although the CCF and the General Secretariat will try and modify that and check that if you raise it, that's a huge amount of data that they've got to analyse. Genuine. And after a lot of campaigning, that was updated, and in fact, a lot of those passports were taken off the database. But in 2022, September 2022, Turkey registered another 100,000 passports as lost or stolen. And they've been revoked for national security reasons. And that effectively was, again, a purge of Turks abroad, civil society actors, some of whom may well be sympathetic to Fethullah Gulen, but we've seen in the UK, we've seen people who are teachers and doctors who write things against Erdogan on Twitter or on Facebook, not particularly nasty things, no campaigning, but just saying that their friends and relatives are persecuted or imprisoned. And that has led to their passports being cancelled. And so they then can't travel because they risk being deported to Turkey, where they will be put on trial for treason or for terrorism offences and put into prison. And which is an absolutely terrifying prospect that Turkey, this ally to the West, sort of buffer zone between the West and Syria, and now playing power broker in the current war, can ride roughshod over all the rule of law and abuse Interpol to such a huge extent. I mean, interestingly, I think I checked earlier that there have been 3 constitutional court judgments in Turkey saying that you can't revoke passports in that way. But it's continued to be done. So, I mean, Turkey is a massive abuser of Interpol in that respect, and I could talk for many hours on it. One other country who's done this recently, as I've seen in some press reports, is South Korea. In order, there have been some high-profile red notices issued, and in addition to the red notices, they've cancelled the individual's passport. So, if a person is stopped in a country where South Korea don't have an extradition treaty with, they get round the extradition issue because, and the person is a South Korean national, because they will then got the passport taken away and then be deported to South Korea. Asylum and are successful. And so it's a very worrying trend for this database allows unscrupulous governments to report lost and stolen travel documents, essentially to circumvent the extradition process and the red notice process, and it's very, very difficult to spot or to check on, and so it's something that we spend a lot of time, the 3 of us, trying to remove red notices and diffusions, but many clients don't know that their passport has been imported or lost and stolen until they travel, so I mean that's my summary of what I think is a really sinister misuse of Interpol's database.
And it is, isn't it? Because it can immobilize you in a different way. It's very difficult for somebody who has a red notice or a diffusion to travel. They often find out about it though. And they can fight it, but when something has been declared lost or stolen and it hasn't been, it's immobilizing in a different way.
And the SLTD database, I think it's become a much bigger problem in just the last several years. To me, it seems like the reason I think so is because the Commission for the Control of Interpol's Files started really mentioning it, and informing the public, so to speak, and saying, in so to speak, annual reports that they've been in communication with the General Secretariat, and they've been amending the rules regarding the SLTD database. In addition to what I already mentioned, how governments put the same individuals back into the database using stolen, lost, travel documents database. So one of the, I'm not sure if there is any real progress in terms of, suppressing that abuse, because in the CCF annual reports, the Commission just says, well, there've been cases of abuse. And then, we've, together with the General Secretariat, we have worked on amending the rules, informing the governments what they can and cannot do with the database. But, it's like telling a child, you can't eat too many candies while keeping the bowl full of candies next to the child. So it's just like it's basically seems like it just works, but I'm not sure if there is any real mechanism, and there is still, again, it's still unclear if Interpol has fixed that problem that the Commission wrote about in its annual report several years ago. That the enforcement mechanism, literally, what they would need is just a simple filter, a simple filter that would match incoming government requests, whether it's red notices, diffusions, messages, or what's the stolen lost travel database, with the names that have already been removed from the database, based, for example, on the Commission for the Control of Interpol's files, decisions in individual cases. We still don't know if that mechanism exists. So we can't guarantee our clients that they will never end up in the database again, at least based on the same charges after we remove them. If we covered it, I think we covered a lot. Unless you want to add something to what we just talked about, we can turn to Q&A. We have several questions. And please, to our viewers, please ask questions. There is a chat. We'll happily answer. So I'll start in order we received them. Ted Bromond, I'm sorry, just a second.
Yeah.
I'll try and he was the first one.
Ted's asked a very complicated question.
Yes.
So so with you, so Ted wrote about Ukraine, and just a second. A question for Ben, Michelle, and Yuri. I had a meeting today with the Ukrainian delegation. Interpol is banned from involvement in military affairs. The Ukrainian delegation was very interested in requesting red notices on Russians for ordinary crimes. They instanced rape and murder of civilians committed in the course of Russia's invasion of Ukraine. Ben and I wrote on a related subject recently, but I would be interested in everyone's take. Are these offenses under Interpol's rules ordinary crimes, or are they military affairs? Michelle or Ben, who wants to take it?
I'll have a go first.
Ben, it sounds like you wrote about this recently, so I'm happy to hear what you think. And I have a couple of thoughts as well.
Me and Ted wrote about it, but not this specific issue. You don't need to apologise, Ted. I mean, I think the issue really is these crimes are committed by Russian invading soldiers, and there are legal concepts about whether when they're acting as combatants or not as combatants by committing rape and murder. But ultimately, they are soldiers invading, and so I think that unfortunately that those horrific crimes are probably classified as, or certainly could be classified as, crimes committed by the military or in the course of invasion or war, and so unfortunately fall under Interpol's prohibition on getting involved in armed conflict. That's my thoughts. I'm not sure I particularly like it, but I think that's probably the position.
Michelle, I hear in your voice, Ben, it sounds like maybe a frustration or a resignation because those crimes are so horrific. And if I were the attorney representing someone who had a red notice related to something like that, that would certainly be my argument. Also, I have seen red notices issued that are active now for people who were charged with crimes that occurred during a military activity or invasion, for murder, for rape, and they've been alive. Those notices have been alive for a long time, and the people are so obviously Interpol is issuing them. The ones that I have seen have been, pretty obvious within the context of the notice that activity occurred during a military activity. They were issued anyway, but we know the screening isn't always very detailed. So, for instance, I've seen them from Uruguay for very, very old cases. I've seen them from Ecuador, I've seen them from Venezuela. So I know that they get issued. What happens when they're challenged? Again, I'm going to argue along the lines of what Ben said, if that's my client. But I share your unease with the idea that we're saying maybe, sorry, we're out of it. That's military, because they're still just common, ordinary crimes at the base.
I think if I was advising the Ukrainian government, I would say issue the red notices and see what Interpol does.
Of course.
Because in fact, again, the red notice isn't the extradition request in most countries. It is just to find the individuals, and obviously they've got to be outside of Russia or Ukraine to be arrested, and then let people argue that they're not ordinary law crimes. But it's a very legally, it's very difficult. Whether Interpol sees it as that complicated, I'm not actually sure. I see a comment from Ali Yildiz that it could work for the Wagner Group. But we've seen Interpol remove the head of the Wagner Group from when the US requested his red notice in, I think it was 2018. So as being politically motivated. And some of you may be aware of the scandal recently of, and I always forget his name, the head of the Wagner Group again, being granted significant finance from his pot of sanctioned money in the UK in order to commence libel action against an investigative journalist. And that's been a bit of a scandal in the last 2 weeks in the UK. Interpol did remove its politically motivated red notices, they said, because it was a US red notice for the Wagner Group. But ultimately, again, if it's not a political crime or predominantly politically motivated, then it should be issued and it should be acted upon.
If I may, I have a different take on that. I actually think that, going back to what you just mentioned about the head of the group removed from Interpol based on politically motivated on Article 3, I think that the charge behind the red notice was election interference, which is a perfectly purely political offense under Article 3. So I think that's like a perfect model case for the repository of practice in Article 3. So I'm not surprised that red notice got removed.
No, you're right. I'd forgotten that.
Right, but so in terms of going back to Ted's question, I actually think that this, at least what it seems to me like what he's talking about, does not fall under Article 3 as a military offense, because the way I think so if we look at, for example, international criminal tribunals, which they cooperate with Interpol, to be more precise, Interpol cooperates with them. They investigate and prosecute military crimes or crimes against humanity. So my understanding is that it's all that falls under that, military a military crime definition. In other words, it's something that's against the rule of the war. So if civilians are targeted, I think that's not a military offense as defined in Article 3 of the Interpol Constitution. I think that, so for example, if there is an international tribunal investigating that particular issue and they charge somebody with a crime against humanity, with a war crime, then I highly doubt that Interpol would refuse to cooperate with the international tribunal in a case like that. So why would they refuse to cooperate with the government based on the same charges? I actually think that Article 3 doesn't apply here. It depends on the circumstances of every particular case. But again, if you take like the tribunal from Yugoslavia, they used Interpol. If you take the International Criminal Court, they all.
Interesting question. Is that different? Is an international? I think Ted and I sort of tried to discuss this recently in an article. Is a red notice issued by a war crimes tribunal, or the ICC, or an ad hoc tribunal, such that it's not political because it's a supranational body.
Yeah.
Or make it less political, or more. It might make it more political even.
But that's a different category that Interpol looks at. So there is they look at the source of the information, right? It's the source of a request. In that particular case, it would be an international tribunal, and they look at the charge as well. So it's not necessarily, it might be looked at, together, but these are still two different categories that they look at. So if it's actionable under, an international tribunal's jurisdiction, why wouldn't it be actionable under national government's jurisdiction? The issue here, I think, is, you're right. I mean, when it comes from a national government that's that is in that war conflict, then it's probably harder for the government to prove that it's not politically motivated or not military. But because again, it's not coming from an international tribunal, which is usually established by more than just two countries in a conflict. But I still think that it's not really clear that it's not going to that it falls under Article 3. I think that many of these instances most probably won't, and I think that Interpol will probably agree to cooperate. Again, just looking at the repository. But that's a great question. I also go ahead, Michelle.
Well, I was thinking about, the international tribunals, even if it's not considered to be political, there has still been an observation of red notice abuse in those tribunals. For example, where the prosecuting body is seeking witnesses to prosecute one defendant, there's been a removal of the red notice in order to get the witness there, to get their testimony. But once they're there and once the testimony is gotten, the red notice is put back in place, or perhaps they're arrested or something. And there's been an observation of the tribunal that this was considered to be kind of a manipulation of the red notice system. So there's not a limit to where these problems can arise. And there's, just because it's a reputable, generally observant of due process and human rights issues organization, doesn't mean that the red notices can't be abused. But I thought that Ben's point was a good one.
I mean, I think it's also worth just sort of highlighting that the extradition to international tribunals is often a very, very different process to classic extradition. I mean, for instance, in the UK, a request from an international tribunal automatically results in surrender. There are very few checks and balances that allow you to resist extradition to an international tribunal. I've heard recently there was an individual surrendered to the Kosovan tribunal using potentially the wrong law, but trying to use an extradition treaty which didn't apply rather than the surrender provisions. But it's when you look at extradition and the international tribunals, most signatories to them, part of the conditions for signing up to the individual or ad hoc tribunals are that if you receive a request from the tribunal to surrender a particular individual, you are required to do so. And there aren't any discretionary bars or reasons that you can give.
I think that that's probably again the same trend that Interpol is following, because it seems like they trust international tribunals more and than national governments sometimes. But that just there's a follow-up question. So to your point, if the Interpol ban does not prevent them from investigating offenses against civilians, it is hard to know what it bans, except desertion. Most of the plausible offenses committed by armed forces are committed against civilians. So again, I think that's just my take. And again, from the examples that can be found in the repository in Article 3, I think that as long as it is against the rules of the war and is considered a war crime or crime against humanity, I think that it is, at least it is unclear if Article 3 applies or not. I think that it might apply to, again, cases against civilians, but it would probably be easier, again, for an international tribunal to make Interpol cooperate as opposed to a national government. It's just, I think that's where, Article 3 comes in, not only in the context of a military offense, a potential military offense, but a political prosecution as well. So, I don't think it's exactly straightforward, but I wouldn't rule out Article 3. I mean, I wouldn't rule out, requests like this actually processed by Interpol and not falling under Article 3. Unless you guys want to say something else about this, we have more questions.
No, I think that's.
Do you want to move on to the next? Okay.
No, just related to that, on that same topic, Yuri, I saw that Ali Yildiz brought up the issue of the tribunals that we've been discussing and Interpol's agreement with them, and certainly Interpol has worked with, in Lebanon and Rwanda. I mean, obviously, its tools have been used to effectuate investigations and to obtain defendants and that sort of thing. So yeah, there's absolutely ongoing agreements that some of them have finished. Sometimes the mission has finished, but that's a part of Interpol that we don't often deal with, but certainly comes up. That's it.
Hassan El Daye, I'm sure I apologize in advance if I'm mispronouncing anybody's name. I'm sorry. I believe that the real problem in Interpol starts when a country, through its NCB, processes the data to circulate a red notice irrespective of a dispute. This needs to be controlled. I think we agree with that. Exactly. Yeah. I think we agree with that. I'm not sure what kind of a dispute. Yeah, right. Okay, so with I'm sorry, just a second.
There's one there, Yuri. It's somebody's
questions.
Yeah,
go ahead.
The Interpol intends to publish an updated version of its repository of practice
of Article 3. Yeah, that's the question I saw. Do you want to comment on that? Go ahead.
I don't. I have been waiting for one for a long time, and I haven't heard they're going to publish one, unfortunately.
I haven't heard that they were going to, amend the current publication. I think that the one that's published it's a second issue, even though it was published years ago. I think that at this point, they probably rely the General Secretary, because it's the General Secretary that published the repository of practice on Article 3, not the Commission for the Control of Interpol's Files. I think that at this point they rely, and that's just my guess, on CCF to develop practice in terms of Article 3, Article 2, whatever. By the way, the rules on data processing say that the General Secretariat may compile, it's not really an obligation, they may compile a repository on the application of Article 2 as well, which we have never seen. So even if it exists, it's not published. But the Commission for the Control of Interpol's Files we talked about during the last webinar has developed, in my opinion, a pretty extensive practice on Article 2. So I don't even know if the General Secretariat is planning on publishing something, in addition to that. Sorry, Michelle, did you want to add something?
No, I was just sneezing. I'm sorry.
Oh yeah.
Although it is true that a lot of the decisions are from the time prior to the rules being amended, right? The new rules becoming effective. So we're due for a new set of decisions. I think that would be a great idea.
Oh yeah,
And I think that, and I do think, as much as we want to demand reform and offer criticism where appropriate of Interpol, I do believe that efforts at transparency, although they may not be at the pace we want or the content that we want, they are ongoing. And I don't see a situation in which there won't be a new repository practice issued, an updated one, because that's one of the easiest ways to work towards transparency. So I also don't know when it will be. I haven't heard anything about that, but it's needed, and I imagine it will come.
Yeah, I agree, and it's true. The Commission hasn't published any of its new excerpts since, I believe, 2019. Which is a bit strange in my opinion, and there's still many more issues that it has to opine on that remain unclear to us.
Although I think,
but the Commission
I think the new CCF. I mean, the new CCF started in March, and so I think they might. Once they've got us some decisions, they might start publishing something.
Yeah, that's true. Well, the Commission in its old version, so to speak, they've published really really useful. Some of this opinion, not all of them are particularly useful. Some of them are so heavily, I mean, they all redacted, but some of them are so heavily redacted that it's hard to say what they wanted wanted us to know. Like, for example, with preemptive requests, it's really unclear. I remember there is an excerpt that they published that really doesn't say anything. It's so heavily redacted. But they have published some really useful stuff, about the right of access and request for reconsideration and so forth. And again, Article 2. They're all very useful. And I also want to mention that we already talked about it during the last webinar, but the CCF decisions is not the only source where CCF gives us an insight into how it applies Interpol's rules, because you can find some of that in its annual reports as well. So I think that we've covered a lot today. Unless Ben or Michelle, if you want to add anything, I think we can wrap up. It was a very interesting conversation. I greatly appreciate it. And we'll see you next time during our next webinar.
Thanks, Yuri.
Thank you, Yuri, for hosting. Nice to see you both.
Sure. Thank you for being here. Likewise.
Bye-bye.
Bye.